Welcome to the Fabulous Fifties and Beyond. I'm Jim Pollard, your host, and today we have an exciting program. We're going to be talking about senior law and estate planning for seniors, and we're going to give you a lot of good information, so you stay tuned, and we'll be right back.
And he'd say, go with what you got. Start from where you are. Give it your best shot. Keep reaching for that star. Get in the race. Keep your own pace. Keep moving and never stop. Just go. Go with what you got.
Welcome back. Our guest today is Whitney Riley, and Whitney is a local attorney, and she'll be talking with us about senior law and things that seniors need to do. I did not know a lot of the things that we'll be talking about until I met Whitney, and she was very good at helping me make decisions that I needed to make. And Whitney, we're so glad to have you with us today and to discuss these important topics, and they are very important for seniors today.
They are.
And what are some of the basic planning documents that seniors should have?
So when I'm meeting with new clients who are either starting from scratch on their estate planning or maybe just coming in and updating their documents, we're typically talking about a living will directive, a power of attorney, a last will and testament, and then depending on what the client's estate planning objectives are and what their needs are, we might also be talking about a revocable trust.
Okay, let's expand a little bit on like a power of attorney, because there are different kinds of powers of attorney, aren't there?
That's right, Jim. So the power of attorney that I see most often or that my clients typically want to get in place is a durable power of attorney. And a durable power of attorney is one that goes into effect as soon as you sign it, and then it stays in effect if you later become incapacitated. Okay, and in a power of attorney, the person whose document it is the principal, and they're naming an agent, sometimes also referred to as an attorney in fact, to act on their behalf, typically for financial and legal matters. Okay, so that is the most common type of power of attorney I see, is a durable power of attorney. But there are a few other types as well. Sometimes clients will have a need for a limited power of attorney. Maybe it's a husband and wife couple who are purchasing a home, and one of them can't be at a real estate closing, so then they would name the other one as their agent to be able to sign for them. So it's limited both in scope, right? It just is for the real estate transaction, and it's also limited in time. It's just good for that one transaction, and then it would terminate. So that was the second type. And then a third type of power of attorney that some of my clients will get in place is what's called a springing power of attorney. And that just goes into effect if the person is incapacitated. All right, unlike the durable that goes into effect immediately, the springing power of attorney just goes into effect if someone's incapacitated. And the document would have a definition of incapacity in it. All right. You know, I also get the question sometimes, okay, if I sign a power of attorney, do I need to get it recorded at the courthouse? Who do I need to give it to? And you know, if the power of attorney, if you're expecting that it'll be used for a real estate transaction, then it should be recorded. You could record it ahead of time, and if you haven't recorded it before that real estate transaction takes place, then it has to be recorded with the deed. And then, you know, as far as who you should give it to, you should definitely put one on file with your bank. You know, that way it's already on file in an emergency situation, they have it. And then the person who you've named as your agent, if you're comfortable with giving them a copy, you can also give them one. I usually have my clients sign multiple originals of the power of attorney. And then if you have a financial advisor, you know, maybe you have an investment account somewhere, I recommend putting one on file with your financial advisor as well.
Does a power of attorney avoid a guardianship?
It can. And that's another reason that I think they're really important, because if someone, let's say because of old age, they have diminished capacity and they need someone to help with their finances, pay bills for them, sign checks for them, if they have someone named in a power of attorney to do those things, then it can avoid a need for a guardianship. In Kentucky, it's one of the few states that still has a 6-person jury trial to determine if someone is incapacitated. So, when you think about a situation that you're already struggling maybe with mom or dad having a health issue, and then if you have to think about, hey, how are we going to pay their bills, and having to go through the court guardianship process, it just kind of exacerbates the level of stress. So you could sometimes avoid it with power of attorney.
Oh, okay. Well, I wondered about that, because that's a question that comes up a lot. Should you file, a court record of a power of attorney or not?
I think it can be a good idea to go ahead and record it. It certainly doesn't hurt. So if some banks, I think, they won't necessarily require that one be recorded at the courthouse. I've also in practice seen that a bank would like to see it recorded, but for real estate transactions, it does have to be recorded. So it certainly doesn't hurt to go ahead and record it. Now, if you can always, the person who set up the power of attorney, they can always change who their agent is or revoke or terminate their power of attorney later. So you would just need to make sure, if you had an old one recorded, that you get your new one recorded as well.
How long is a power of attorney good for?
If you do a durable power of attorney, the type that goes into effect straight away, it's good until you revoke it or until you pass away. A power of attorney is just effective while somebody's living, so it's no longer effective when someone dies.
That brings up another good question then. How do you protect yourself or your relatives or those who are left behind if the power of attorney ceases at death?
So in addition to a power of attorney, you should have a will in place. Okay, in your will, in addition to disposing of your property, a will's going to say if you want to leave specific items to certain people. It'll typically include a remainder section that catches everything else that maybe you haven't specifically bequeathed to people. But to your question, Jim, it also, in your will, you also name an executor. And it's the executor who would take over when you pass away to help administer your estate. So at that point in time, people are always thinking, well, should I avoid probate because my bank account gets frozen? And that might be true for a short period of time, but as soon as the executor is appointed, or if someone doesn't have a will, it's an administrator, as soon as that person is appointed by the court, then they would have the ability to collect all the bank account proceeds and then be able to write checks to pay bills and things like that.
All right, if a checking account is in is it joint survivorship account?
Right.
With my daughter and myself, can she still write checks on?
She can. And so sometimes when people do, I've done a presentation before, something along the lines of estate planning without thinking, right? Because when you add somebody as a co-owner, you're not really thinking about the fact that you are doing some estate planning with that. And what I mean is, you, for instance, Jim, you've got 2 kids, and maybe you wanted your estate to be divided 50-50. Well, if you have one child as co-owner of your bank account, when you pass away, all those proceeds pass to the survivor. Now, you always hope that that child does the right thing and splits it 50-50, but they wouldn't necessarily have to. So, on one hand, the convenience of it is that child is able to continue writing checks without maybe a short delay. On the other hand, that account may not be disposed of how you necessarily intended.
Well, I asked that question because I could see a problem. There could be some immediate financial needs that need to be taken care of.
Sure, and usually, like in McCracken County, for example, probate court is held every Monday morning, unless it's a holiday. But so you can get someone appointed as administrator or executor in pretty short order.
Okay, because that was a question that I personally had
Sure.
and wondered about, and I know that we have set up some joint survivorship accounts for that very reason. And if is that good? Like if it's an automobile and other things like that in both names? And
I mean, you can. It just really depends on. I mean, husband and wife couples, for example, a lot of times will own their property jointly with right of survivorship, right? Whether it's maybe their home or vehicles, bank accounts. So at the first spouse's death, a lot of times property will just pass automatically to the surviving spouse because of the joint ownership with survivorship. Now, when you do that with children or certainly non-relatives, you really need to think through how that's going to play out and if it is consistent with what you have set up in your will or trust.
okay, well that's some good answers to some questions that I think all of us have.
Sure.
And the irony of it is we don't think about those questions until it's almost too late.
Sure.
And death is uncertain. I mean, it's no respecter of age.
Yeah, that's right.
And that's the thing that we have to be careful of and watch out for. Well, we're going to get into talking about wills, and there are different types of wills, or
There's one type of will. There are multiple types of trusts. And maybe before I mention the will, another document important while someone is living would be a living will directive. I didn't want us to skip over those because your power of attorney is very important while you're living, but a living will directive that covers medical decisions is also really important as well. And in your living will directive, what you're doing is you're naming a healthcare surrogate to be able to make medical decisions for you if you couldn't communicate with the doctor, okay? So long as you can continue to communicate with your medical providers, you'll do that. But you can name a healthcare surrogate, and I also recommend that you name an alternate, just in case, if for example, if it's husband and wife who have named each other and they're in a common car accident, then they have an alternate named, all right? A living will directive typically would include a HIPAA release so that medical information can be released from your providers to your healthcare surrogate. And then they also go into the directive portion, which is what most people think of with the living will directive, where you're deciding about life-prolonging treatment, artificial food and water, and organ donation. And in each of those sections, you can say, I do want this, like life-prolonging treatment. You can say, I want it, or I don't want it, or you can leave it up to your healthcare surrogate to decide at the time. And that can be a good option if you're the type of person that says, I want my family members to be able to talk with the doctor to see what my prognosis is. That can be a good option, but certainly some people feel strongly one way or another and want to make the decision themselves. So the living will directive would just be in place during your lifetime. Your power of attorney is just in place during your lifetime, and then at death is when a will would take effect.
I can see both sides to the living will directive. Well, the hard part, it seems like to me, would be to put that ultimate hard decision on someone else to make at that time, because and most of them are going to want to do the best they can for you, but maybe that's not the best at times, And I've seen that happen in the past where someone had that power and they just kept on and on and on with the person.
Well, and it's really important if you choose that third option where you're leaving it up to your healthcare surrogate to decide, you really need to have a serious conversation with that person and say, hey, under these circumstances, here's what I would like to see done. You can also leave a letter of intent with regard to medical decisions like that too. So rather than leaving your healthcare surrogate just kind of out in the blue guessing, you should really address that with them.
Yeah, well, good. Well, we've covered a lot already, and I've gotten educated. We're going to take a break now, and then we'll be right back in just a few minutes, okay?
We all want to get the most for our money, and no other investment yields as great a return as the investment in education. A recent study shows that West Kentucky Community and Technical College adds value to our region through what it's spending, jobs it provides, and added income made by its graduates. Investing in WKCTC has proven results. Let's do the math. For every $1 a student invests in their WKCTC education, they'll receive nearly $7 in higher future earnings than those without a degree. Higher education is positively associated with lifestyle changes that lead to taxpayer savings and societal benefits in better health, less unemployment, and reduced crime. So total benefits to state taxpayers is over $63 million. This means for every tax dollar spent supporting students attending WKCTC, taxpayers will receive nearly $5.50 in return over the course of the student's working life. In fiscal year 2015-2016, WKCTC employed 549 faculty and staff with a payroll of $21 million. The college also spent another $14.5 million on goods and services. This generated over $24 million in added income to our region, or the equivalent of supporting 578 jobs. During the same year, WKCTC alumni and students generated over $117 million in added income to the community. Together, the local impact of having a strong community college in our region was over $141 million in added income, which means more trained workers, more jobs, and a stronger economy. Do the math. WKCTC is good for the region and good for the state.
Welcome back. I'm Jim Pollard, your host, and our guest today is Whitney Riley, and we're talking about some very important decisions that we need to look at in our life, and especially as you get older. I tell people, you know, I am old. I don't feel like it all the time, but sometimes I do. And these are things that we really don't, maybe we don't like to think about, but we need to think about. And we just started mentioning a will, and what is required in our state as far as a will is concerned?
So in order to be able to make a will, somebody needs to be 18 years of age, and they also need to be of sound mind, okay? And then as far as the will signing requirements in Kentucky, if it's a typed written will, it has to be signed in the presence of 2 witnesses, okay? 2 witnesses also sign the will. And then in order to make the will self-proving, so that the witnesses don't have to come and testify when someone passes away and confirm their signatures, to make it self-proving, all of those individuals would sign in front of a notary. Okay, so the testator signs, 2 witnesses, and a notary would make it self-proving in Kentucky.
Okay, what happens if you don't have a will?
So if you don't have a will, then the state has a default plan as to how your property gets distributed. And in Kentucky, if you're married, 1/2 would go to your spouse, and 1/2 would go to your children if you have any. And I think that surprises a lot of people. I think that they just assume if they're a married couple, you know, 100% of their property would go to their spouse, but that's not the case. So 1/2 to spouse, 1/2 to children. If you didn't have any children, then it would go to your parents. Well, if you didn't have children but had grandchildren, it'd go to your grandchildren. But if that wasn't the case, it'd go to your parents or your siblings before making its way all the way back to your spouse. So, you know, if you own property, we were talking about this a little bit ago too, but if you own property jointly with right of survivorship, you know, that's not going to pass through your will. Your will just will control what you own in your individual name, all right? And it only controls those assets that you don't have a beneficiary designated on file. So if you had life insurance, or you have an IRA, or another type of investment account that has a beneficiary designated or might be payable on death, then that will pass outside of your will to whoever you designate.
Well, I had wondered, because I know that I had heard different stories about what happened if you didn't have a will. And so actually, basically what happens, half goes to the surviving spouse,
Right.
and the rest is divided among other half among the children.
That's correct. And I
And
think that
that's-
surprises a lot of people. In fact, I have a client, an estate I'm working on right now, where one of the spouses passed away without a will and a large investment account, and half of that large investment account is going to go to, a 20-some-year-old daughter.
Yeah.
So,
and nothing can be done about it.
right.
That's interesting. Well, again, who can make a will?
So anybody can make a will so long as they're 18 years old and still of sound mind.
Okay. And does everyone need a will?
If you want to control how your assets are distributed, then I think you need a will. Most people think, oh, my estate's not large, I don't need a will. But when you really think about the fact that all of your property ownership includes your real estate you own, your bank accounts, could include retirement accounts you've been saving towards, might include life insurance or annuities, vehicles, could include business interests, for someone who's a business owner. So those things really do add up quickly if you sat down and think about what all you really own. So, in my opinion, if you want to control how that property is disposed of and who serves as your executor, then you should have a will.
Okay, so you've got a will, and you decide you want to change it or terminate it. What do you do?
So you can just do, if you're just changing maybe one or two sections of your will, you can usually accomplish that with what's called a codicil. A codicil is just a will amendment. If you came in and you just wanted to change your executor, the order of executors, you could usually accomplish that with a codicil. If you're changing a lot of things, sometimes it's easier to just redo the whole thing. But yes, so long as you continue to be of sound mind, you can change your will at any time.
Okay. I don't know how to ask this question. I'll just go on. What is a trust now that we talked about? I mean, I know what a trust is somewhat, but let's talk about what a trust is.
Sure. So there are several types of trust. The types that I see most often would be, or that most people think of, would be a revocable living trust that someone sets up while they're living. Okay, the person who sets up the trust is called the grantor or the settlor. And in a trust document, you are putting property, you're retitling property in that trust and naming a trustee who manages the property for the beneficiaries. Okay, the trustee serves in a fiduciary role to manage properties in the best interest of the beneficiaries. So someone who sets up a trust, they might be the beneficiary of the trust while they're living, and then at their death, the trust reads similarly to the will or to a will in the sense that it says how property gets disposed of. So, as far as reasons to have a trust, some people who are concerned with privacy and don't want their property passing through probate and becoming a public record, they might want to do a trust so that because any property that's in your trust at death avoids probate. Okay. It doesn't, and a trust document itself doesn't become public record like a will does. Okay, so if you're concerned with privacy or just ease of administration, like I mentioned, property that's in trust doesn't go through probate. So some people like the fact that, okay, if someone passes away, the successor trustee steps in and can immediately, I say immediately, depending on the circumstances, may be able to, in short order, distribute out that trust property to the beneficiaries. It might be a little bit more seamless than having to go through probate. Another reason to have a trust might be if your beneficiaries aren't the best money managers. They need a little oversight, they need a little help with managing finances. You might name a trustee to manage property for instance, your kids or grandkids until certain ages. And, sometimes people will do staggered distribution ages, get half at this age, the rest at this age. So help with financial management would be another reason someone might have a trust in place.
So let me get clear on this. If you have a trust set up, you avoid probate with what's in the trust.
That's right. You do. Mm-hmm.
All right, let's talk about probate for a minute. How lengthy is probate?
Well, it really, I hate to always give that lawyerly answer of it depends, but it really does depend on the type of property we're talking about. You know, probate estates that have business ownership interests in them can be a lot more complicated than if we're talking about just a vehicle and a bank account, okay? But at a minimum, once the executor or administrator is appointed, the estate has to be open for at least 6 months to allow for creditor claims. Okay, so we're talking a minimum of 6 months. And then it could be longer depending on, like I said, the type of assets you're dealing with. And also, you know, the executor or administrator, they've got to file final tax returns and handle that kind of financial piece. So depending on if there's delays in getting tax returns prepared, that can really dictate how long probate lasts. But like I said, at least 6 months.
So it can be a lengthy process.
It can be. Mm-hmm.
Well, you know, there's a lot more that we could. We got just a little bit left. Can you avoid probate?
You can avoid probate. So to avoid probate, if that's the client's goal, usually they will go the revocable trust route. You know, retitle property in the name of their trust. Joint property ownership with right of survivorship can also avoid probate. Okay, so there certainly are strategies to avoid probate. Sometimes people want to go ahead and gift property while they're living. And if you've gifted property out of your name, of course it would avoid probate because you don't own it at death, but there's certainly strategies if that's someone's goal. Mm-hmm.
Well, we kind of touched the surface, scratched the surface. We need to do this again sometime.
There you go.
But I really appreciate you being here with us today, and we hope that you'll stay tuned and be available for our next program. And remember now, use it or lose it.
Can't see as well as I used to. Can't run as far or as fast. Sometimes I think that the old me is becoming exactly that. But when I start thinking of all I don't have, that's when I tell poor me Beethoven was 50 and deaf as a post when he wrote his Ninth Symphony.